I would like to welcome you all to the latest DeCarbCH lunch lecture. I'm Gianfranco Guidati. As usual, I will be your host for the next 45 minutes. The subject of today is super important and super interesting. And especially since I'm an engineer, many of us in this big project are engineers, and we tend to think this is the best solution, just take it. And we know that the real world doesn't work like that. There is, first of all, do people really want this? This is an aspect that the DeCarbCH is represented by a group also ZHAW. And then, are there actually rules made by us that prevent this? Are there legal requirements that we are missing maybe? Are there things that we should change in the law in order to foster the distribution of renewable energies, or especially the heating technologies that we're looking at in DeCarbCH? And today we have Professor Andreas Abegg from ZHAW speaking about one aspect actually, but it's a central aspect of DeCarbCH, about district heating networks, district heating supply, a legal classification from his point of view as a lawyer. So, Andreas, I'm very much looking forward to your presentation, and I would like to hand over to you.
Thank you, Gianfranco. Now, for us lawyers, it's important to know about the technical solutions. It's important to know about the economic and political goals, about the concrete plans, what kind of legal problems you all encounter. And I would like to thank, therefore, all of you that take time to inform us about their work, about their plans, about their problems. That's the municipalities like the city of Zurich, the Federal Office of Energy, and the many research colleagues. The collective wisdom in this case encapsulated in this research is a testament to the collaborative spirit of our sweet community, if I may say so. In this talk, I primarily address non-lawyers. Lawyers may find further details in an article I published with Nagia Musliu at Sui Generis. The link is at the very last slide, so you'll have to stay with me for that. Now, from the start of a district heating project to its completion, there is a complex structure of laws and regulations that govern it. Today, I would like to give you an overview of the individual building blocks of this legal structure. These are important to the system as the pipes that run under the streets. Firstly, we want to know who is responsible for the planning, the building, the operating of a district heating network, and who determines the rules. In the case of district heating networks, the tasks are divided between industry and government on the one hand, and between the various levels of government on the other. Now, energy supply, including by means of district heating networks, is primarily the responsibility of the industry. So there is no primary duty to deliver heat. Now, with regard to the state, the cantons are responsible for measures affecting the consumption of energy in buildings. It is therefore the cantons and the communities, the municipalities, that are mainly concerned with district heating networks. In addition, the canton and also the municipalities are primarily responsible for spatial planning. I will come back to that. On the other hand, the Confederation merely lays down the principles on the economical and rational consumption of energy. This is what it does in Article 45 of the Energy Act. In particular, the Confederation orders the cantons to give priority to the use of waste heat whenever possible. Now, the spatial planning. The next question is how to coordinate a district heating network with other spatial activities. Now, in spatial planning, Switzerland follows a multi-tiered system that corresponds to our federal system. Mainly the cantons and municipalities do the planning. The federal government merely defines the principles. This does not exclude the possibility that the federal legislature may lay down rules, detailed regulations for certain issues in addition to these principles. However, this is currently not really the case with district heating networks. The cantonal structures or the cantonal structure plan, the Richtplan in German, is the supreme plan which coordinates spatial activities comprehensively. It provides information on the status and the planned development of the supply sector. It binds the authorities, however, not the owners. And it's also not specific on each and every parcel. Projects with a significant impact on space and the environment must have a basis in the structure plan. Such an entry in the structure plan is imperative, for example, for projects with that require large areas, which have a strong influence on the canton's use and supply structures, or which trigger a strong need for coordination for spatial, organizational, or political reasons. So large energy production plants, for example, such as wind farms, hydropower plants, must be included in the structure plan. This obligation has led to the delay of very important projects recently, such as the Grimsel Dam. Whether a district heating network must be included in the cantonal structure plan depends now on the impact it has, or on the impact that the specific network has on the planning. Networks serving individual neighborhoods merely generate less need for spatial coordination, obviously, than networks covering larger parts of the municipal area or that go even beyond the municipal boundaries. The former does not have to be included into the spatial plan. The latter, however, does, by virtue of federal law. Compared to other spatial activities, an entry in the plan has the effect of a kind of reservation in favor of the planned district heating network. So competing projects in the future must seek coordination with the already registered project. The next planning level is the communal land use plan, the so-called Nutzungsplan on the municipality level. These plans are now parcel specific and the entries bind or can bind the owner. It is unclear whether the municipalities are allowed to specify the type of energy zone that is, or whether they are allowed to specify the type of energy source to be used in the energy zone. Or only, it is said that maybe they are only allowed to put in a minimum amount of renewable energy. The main issue is that if such an entry led to a monopolization of a particular energy source, it would interfere with the guarantee of ownership and economic freedom. Such measure should therefore have a basis in a communal statute, and a specific energy plan should demonstrate a balanced, proportional approach. Now, after we have planned the grid, we want to build it. What kind of permissions do we need? We need permissions of three kinds. Firstly, we need a building permit. Secondly, we need permission to use public land and public goods. And thirdly, we need also permission to use private land. Now, anyone wishing to build the necessary pipelines must obtain a building permit. Cantonal law governs these procedures, and there are also principles based on federal law. In particular, permits for buildings outside the construction zones are difficult to obtain. To build pipelines or other type of infrastructure outside the construction zone, an exemption permit is required. Now, the purpose of this exemption is to separate the settlement area from the countryside. Strict requirements apply. The exemption is only available if the purpose of the installation requires really a location outside the construction zone and the infrastructure does not conflict with overriding interests. Now, three remarks to that. Firstly, fiscal interests alone, because the construction of a pipeline is cheaper outside the building zone, or just because there are fewer objections by neighbors, cannot justify the construction outside of the building zone. However, cantonal authorities will grant an exemption if for technical or operational reasons, the installation must rely on the location or piping outside the construction zone. This would be the case, for example, if the district heating source is outside the construction zone, so there needs to be a connection, or if space for piping is not available in the construction zone or is not suitable. Thirdly, although the plant itself and the heating network is not of national interest, because usually it's just a limited area, the legislator, however, has declared the use of renewable energy and its expansion to be of national interest. So, in my view, this also applies to heating networks. The second permission we need is a permission to use public property and public goods. Heat for district heating is regularly generated from public goods, surface water, groundwater, wastewater from wastewater treatment plants, or waste incineration. This is regularly a so-called exclusive use concession because it excludes other people from a similar use. Now, the special thing about this exclusive use concession is that it has the protection of legitimate expectation and the guarantee of ownership. This means that the state is largely bound by the initial terms agreed with the operator, and that can last a very long time. Furthermore, the construction of a district heating network requires public land to lay down pipes, to build other parts of the plants, such as a storage or a power station. Now, the state may charge fees for both types of license. It must, however, be neutral from competition. Apart from this, the public authorities have a wide margin of discretion in setting up the fees. Depending on the legal basis, the fee may be reduced or even waived if there is a special public interest in the declared use. Thirdly, we may also need private land for economic or technical reasons. Here we must also make a distinction, and the distinction is between two approaches how to obtain the permission. Rights of transit are primarily to be secured by means of private law. So by building rights or servitude, and one has to pay for that. If, however, the state wants to oblige private individuals to tolerate the transfer, it needs a legal basis in the statute. Various cantons, such as the canton of Zurich, have such a legal basis, whereby they can then expropriate even private individuals if necessary. In the canton of Aargau, landowners are obliged to tolerate the transmission of piped energy in their territory, even if their property is not developed, is not accessed by the heating network. Now, next step, if the municipality wishes to entrust the planning, construction, or the operation of district heating networks to its own company or to a third-party company, the question arises whether these contracts then should be open to public tender. In this case, we must distinguish. Firstly, public contracts, particularly work, supplies, and services, are subject to competitive tendering. In this case, for example, where a community wants to operate a district heating network itself, but has it planned and built by a third party. That's the kind of typical case. Secondly, public invitations to tender must also be issued when a public entity entrusts a public task to a third party. However, public authorities can adopt in this specific case the rules for the public procurement. The city of Zurich, for example, has recently done so. That makes it then easier to have this public procurement. Thirdly, if the community wants a district heating network to be operated by a private supplier without entrusting a public task, so merely handing over the task to a private party, public procurement law does not, in principle, apply. However, there are two exemptions to this exemption. Public procurement may also be involved if, for example, the municipality allows to build and operate a network which is in the public interest again, or which by the end of the concession period returns to the municipality with a significant value. And this would be like the first case, when the state orders a third party to build something that then comes back to the state. Secondly, the second exemption to this exemption, the award of a monopoly concession. For example, the sole right to operate a district heating network in a certain area must be put out to tender. Now, if a municipality wants to escape the invitation to tender because a third party could build a second network in the same area, this, in my view, would be a thin argument. Some cities have tried it that way. I wonder whether this really holds up to a legal test. So, in the end, I think in most of the cases, public tendering will be necessary. Now, district heating systems depend on the highest possible density connections. The public authorities may therefore wish to oblige private individuals to connect to a network. Such a connection obligation must be based on a legal basis, and it must be in the public interest, and it must be proportioned. These requirements, they depend on the degree of intervention, namely whether the measures strongly influence past or future use of the property. If, for example, an owner profits from an economically attractive purchase of a district heating, and then the changeover takes place in such a way that the owner can amortize their existing heating solutions, there are only minor restrictions. In an earlier case concerning a gas grid connection, the federal court had ruled that in the case of an old building, additional costs to change amounting to 50% were incompatible with the guarantee of ownership. But the federal court also said that certain additional costs can be reasonable and can be allowed. Now, another problem follows from this. In the case of a territorial monopoly, district heating companies have a market power and thus be subject to the Antitrust and Price Control Act. Within the scope of its responsibilities, the Swiss Price Monitor Office, the Preisüberwacher, monitors the price development of district heating supplies as early as in 2014. It recognized widely different tariff structures and held out the prospect of identifying expensive suppliers in the future. It did then so 2 years later. It examined the tariffs of, for example, Bern and Horgen, and made then recommendations, and these recommendations were later followed by the municipalities. If there is an obligation to connect, the question arises as to whether there is a right to access to district heating networks. When someone asks to be connected to district heating network, we must make a distinction between privately operated and public services. Private district heating suppliers must connect and deliver if required by the initial use concession. So if the municipality at the very beginning inserted a clause that would oblige suppliers to connect, this would be the case. Otherwise, in principle, there is no such obligation. Private district heating suppliers, however, are subject to a contractual obligation if no valid heating alternatives were available to the specific purchaser, and if there was no legitimate reason on the part of the company to refuse the connection. Now, this hardly, I think, is ever the case. If a municipality now, however, defines the supply of district heating as a public task, a right of connection exists if the company cannot present sufficient factual reasons for unequal treatment. Now to a conclusion. The legalities that underpin the planning, construction, and operation of district heating networks are not just footnotes in a technical manual. Neither are there mere barriers to a modern technology. They ensure that we use technologies and resources responsibly and in alignment with fundamental rights and the public good. In doing so, they provide for democratic legitimacy and for public acceptance. Yet, as we stand on the brink of significant expansion and innovation in district heating, we face key legal challenges. These challenges can call for more legal examinations. Now, this leap into legal depth requires some expertise and resources, something that I think some municipalities may lack. It will be therefore crucial to help municipalities not only with technical development, but also with the legal requirements, with the legal regulation of district heating networks. Now, thank you for staying tuned. I look forward to your questions and the discussion.
Thank you very much, Andreas, for this excellent overview